Good morning, everyone. Thank you all for coming here. It's wonderful to see here the Langham Hotel for the 2026 edition of the Brown Rudnick European Litigation Funding Conference. As some of you may remember, we had our first conference just after COVID in 2021, and it now seems like a really long time ago. Today, litigation funding is not only used as a tool to achieve access to justice, but also as a tool for businesses to realize value for their claims. And it also has become a fundamental collective redress, fundamental to collective redress in Europe and in the UK. At today's conference, we will aim to capture the outlook of where we are in the market and also look at the trends, the deals, and the challenges that are shaping the industry, and also look at opportunities that we have in the industry now and looking ahead for next year. We're fortunate again today to have business leaders from all over the world and funders and investors joining us today. For what hopefully will be a candid and useful exchange of ideas and valuable perspectives on the market. Special thanks to all of our panelists who are all experts in their fields for their investment of time ahead of the conference and to help curate the topics that we will all be focusing on today. So now it's with the great pleasure that I introduce our keynote speaker, Dolf Segaar, who is a leader in the sports industry, and he will talk to us today about one of the most high-profile cases launched this summer, the Justice for Players Foundation against FIFA and several European football associations on behalf of female and male football players. Please join me in welcoming Dolf.
Good morning, everyone. Yes, my microphone is working. Thank you, Elena, for this kind introduction and for inviting me to talk about the class action that launched at the beginning of August, where we made a press release and announced that we will start a class action against FIFA and national football federations on behalf of professional football players, and as Elena said, for men and women who have played for professional football clubs in Europe and the UK since 2002. Now, there are, of course, a lot of claims, class actions relating to cartels and abuse of dominance power, but this is the first claim, class action, that involves the world of sports, especially relating to workers' rights. And in the view of the foundation that I represent, FIFA transfer rules infringed those EU rights, as I will explain further on. But let's first take a step back into history to explain a bit of the background of how this class action started. And you will all have heard, at least most of you will have heard about the Bosman case in 1995, where he was the first professional football player to challenge the transfer rules of FIFA. Bosman, he was a Belgian professional football player. He was not able to be transferred to a new club even after his employment agreement with his existing club terminated. Under the existing FIFA rules, you can only be transferred at a time even after the employment agreement terminated, when the old club and the new club entered into a financial compensation agreement. And according to the EU Court of Justice, where he claimed that the rules infringed the EU law rights, he was given an applause by the judges, saying that indeed those transfer rules were against EU treaty on rules on free movement of employees and fair competition. Then, to safeguard the financial stability in football, the FIFA established new rules that allows players to be indeed transferred according to the Bosman ruling after the agreement terminated without any financial compensation. But under the new rules, a compensation is still obliged to be paid if you want to leave a club during the existence of the employment agreement without just cause, or when the new club and the old club come to an agreement in order to sell out the player, to buy out the player, and that he will be transferred with a certain transfer fee to be paid. And these new rules are mentioned the regulations on the status and transfer of players, the RSTP. And these rules are in place, well, very quickly after the Bosman ruling, but anyway, since 2002, they are indeed implemented in the FIFA regulations. And that brings me to the second time that the transfer rules were challenged, and which is the direct cause of the class action that I'm discussing today. And that is the Diarra case decision of the Court of Justice of the EU in October 24. And like Bosman, it all started with a courageous and very brave guy in this event. It was Diarra, Lassana Diarra. He was courageous enough to fight for his rights and to go against arguably the most powerful sports organization in the world, being FIFA. So Diarra challenged the FIFA regulations on the status and transfer of players, and that blocked his move at the time to Belgium club Charleroi from after leaving his previous club Lokomotiv Moscow. According to Article 9 of the RSTP, you need an international transfer certificate. You cannot leave without the federation issuing a certificate. And if you have a dispute with your old club, it is unlikely that your national federation will issue such a transfer certificate. So that's one of the provisions in the RSTP. Another provision which was challenged was Article 17 of the RSTP, which say that the player must pay a compensation when he terminates his employment agreement before its expiration date. And that in itself, it's allowable to buy out your contract. But according to the FIFA rules, it was not very clear how this compensation was to be calculated. It was a bit a black box, and it was a case-by-case basis it was established. And in many cases, you had to go to FIFA dispute resolution chamber or to CAS in order to get your compensation established. And secondly, in this Article 17, your new club may become jointly liable for the compensation to be paid, and the new club, even like the player itself, it was not clear to them what exactly the amount could be. So you took a risk if you hired a player who was in dispute with his former club. And Diarra argued before court that especially those three rules violated his rights to free movement and fair competition under the EU treaty. And indeed, on the 4th of October 24, he was, his claim was accepted by the European Court. And they mentioned that indeed the FIFA regulations contravened EU law and competition law. And I quote one of the decisions, the provisions that the court provided. It says, the rules in question are such as to impede the free movement of professional footballers wishing to develop their activity by going to work for a new club. So this very important ruling confirmed that professional footballers are workers under EU law, and their right to mobility, being the transfer, must be protected. And it took Diarra much time to come to this decision. He started in 2015 his claim against his former club, and he was ordered by the dispute resolution to pay about 10 million euros to Lokomotiv Moscow. That was upheld, his appeal by against this decision by the Court of Arbitration of Sports. And then in 2015 he started before the Belgian courts a claim for damages because of those rules of FIFA, and he claimed about 6 million euros. And in 2022, the Belgian courts decided to ask the European Court of Justice whether or not the FIFA transfer rules infringed the EU law provisions of free movement and fair competition. And indeed, in 2024, the court decided that it does. So it took a long way for him to come where he is now, and he's now still having disputes before courts against the Belgium Federation and FIFA in order to claim his damages. And Dayer was not on his own, and he didn't achieve this landmark victory all by himself. He was supported by the important players' union FIFPro Europe, which recognized the unfairness of the rules of FIFA, and they took the important decision to support Dayer in his fight. And he had very distinguished lawyers from the firm Dupont-Hissel, Martin Hissel and Jean-Louis Dupont. And Jean-Louis Dupont was also the guy who took Bosman to court and helped him in the Bosman ruling. So he is very famous in this football industry fighting against FIFA. And as a result of the Dayer case, FIFA indeed changed temporarily its rules, but that's only for a short period of time. And experts say that these new rules that are in place since the Dayer case are still not in compliance with EU law. And even after a year that the Dayer case was provided by the European Court, there's still no new rules of FIFA with regard to transfer. So this is something that we as a foundation take very seriously. And the Dayer case gave us the green light to a more concerted legal action on behalf of all players that were active in the EU and the UK during a period from 2002 till now for the loss of income caused by the unfair FIFA rules. And that is, as you will understand, the purpose of our foundation. However, this legal action will not only focus on the financial side, because we are equally committed to achieving substantive and sustainable new rules that comply with EU law. We are a foundation, the Justice for Players is a foundation independently, and we are incorporated mid this year and established as a non-profit organization. I have two other members within the board. That is Lucia Melgert. She is the chair of our board. She is a class action specialist. And we have Franco Baldini as an ex-football player and former technical director of Roma and Tottenham. And he worked closely together with Fabio Capello, first at Real Madrid and later as his assistant manager at the national team of England. And I've been kindly introduced already, so I can skip that part. We have a great legal team supported by Finch Dispute Resolution. Koen Rutte is leading this claim on behalf of the firm of Finch. And Koen is here as well, so if you have during the day other questions, you can, of course, address Koen. We started the class action in August of this year, as I mentioned, by sending letters to all national football federations in the EU and the UK. And we have sent specific letters of action to 5 selected national football federations of the Netherlands, Denmark, Belgium, France and Germany, and of course to FIFA. And we have sent this to all national federations since, according to the EU decision in Dayer, all national federations and FIFA together form an undertaking, and they have jointly implemented and maintained the transfer rules, and because of that they are seen as one undertaking and therefore jointly and severely liable. We will bring proceedings before the court in Utrecht in the Netherlands against those 5 football federations and FIFA. And the Dutch Football Federation, which is included in this claim, of course, is the anchor defendant. And we choose the Netherlands for this action since there is an act of 2020 which provides flexible rules, so to speak. It makes it easier to settle mass claims collectively through the Dutch courts. So that's the reason this is all concentrated in the Netherlands. And as I said, we are looking for financial compensation on the one hand. We have research by economic experts Compass Lexicon that found that FIFA transfer rules have cost players approximately 8% on average in lost salary during the time that they were active as a professional football player. But even important, we want FIFA to change the transfer rules so that they fully comply with EU law in order to protect current and future players. The players from the Netherlands do not have to register. That's an opt-out system according to this new legislation in the Netherlands. And players from abroad, domiciled abroad, will need to register, and that can be done through our website. And we will need to demonstrate before court, first of all, representativity through the number of players that we have registered, but also press releases can give guidance to the representativity and support of other representative organizations as FIFPro or the national player unions. And we launched in August, which was very successful. We had media coverage all over the world, major outlets in the Netherlands, across Europe and in the US. And the case is fully funded by Demonor. That's a funder based in Belgium. The decision of the Court of Justice, which already gave some guidance to questions regarding liability, and the report, as I mentioned, of Compass Lexicon that calculated the 8% of loss of salary damage, made Demonor decide to step in and to fund the subject litigation. And FIFPro Europe issued a statement on the date of our launch that they fully support the claim. And that's of course important, as I mentioned, that it's important to have a player union and especially the FIFPro Europe Union to support that what we are doing. And now I anticipate that you may think, well, those players, they have already earned enormous amounts of money, so why do they need to have this class action anyway? But I hear this remark very often from people, why do you start a class action for those players? But in fact, it is only a minority that have this huge wealth out of football. There are several reports that show that, let's say as an example, the global report of men football by FIFPro, they found that more than 45% of football players earned less than $1,000 a month, and that's only 2% of the players that received $720,000 or more per annum. So it's only a small group of players that earn a lot of money, and we are trying to find compensation for the group of players that are not in this top level, because we do not only believe that the rules are unfair, but we also have we see also a direct material impact on thousands of players, on their careers, their futures and their families. And this class action against FIFA is unique in Europe, as mentioned, but we have seen a recent equivalent in the US, in a class action in the US relating to the National College Athletic Association, the NCAA. There was a landmark settlement in June of this year, where the NCAA will pay the students and former students an amount of in total $2.8 billion for the infringement of US antitrust law by the NCAA and the infringements related to the image rights of those players. And what happens with this settlement, with the $2.8 billion, that the economic power shifts fundamentally to college athletes, where it was first with the NCAA. You can now see that the power shifts to the athletes. And that is something that we want to achieve as foundation for professional football players as well. We want to, that's our aim, create a better balance of power between clubs, federations and players. And the post-Diarra class action may only be the beginning. I will mention shortly another case which is pending in Belgium and which has a hearing on the 27th of November. And that is a famous case called the Royal Antwerp case that has been decided by the European Court of Justice as well. And as well, it relates to the homegrown player rules. I will not go into that in much detail, but it is important to know that the European Court said that those rules infringe free mobility of players as well. The Belgian court will have to decide, and it will probably be in the line of the European Commission. And the outcome of that Belgium decision is likely that will lead to another football-related class action. And this week, important to mention as well, is that the European Parliament issued a report on the European sport model. And it has reconfirmed that there is a critical need for the transfer system of FIFA to comply with EU law following the decisions by the European Court of Justice. And in a statement from FIFPro, it was mentioned that they welcome this report by the European Parliament, and it stresses again that as a significant part of the European economy and its social fabric, player unions will protect and promote fair competition and free movement to operate in compliance with European law, fundamental rights and public regulations. So all these new developments in Parliament, in court, will support our claim against FIFA. And I do not exclude that this is only related to football. I'm sure that this will be in other sport federations more or less, maybe on a different level of impact, but the rules are comparable, and well, it is not unlikely that there are same issues in those federations. So far my introduction to the foundation and the class action that we are preparing for. If there are any questions from the room, I'm happy to answer, or more the details, more with the technology of the legislation. Koen is here as well to answer any questions that you may have. And if not, then I'm happy to give the floor back to Elena. So,
thank you.
Thank you. Thank you.